Hi, so my name is Will Watson, and today we'll be covering the topic of animal rights laws. So, the topic of animal rights is uniquely relevant at the moment, particularly because a bipartisan effort has just succeeded to federally criminalize animal cruelty. And for such reasons as this, I decided that I would talk about them today for class. And some of the relevant statutes ruled by judges in the state of Arkansas, as well as two U.S. Court of Appeals and one that was ruled in the United States Supreme Court. But first, let's establish some of the history of what are animal rights and how do we define what animal rights actually are. So, what rights are afforded to animals and how are they different than our own as humans? That's a big question we need to answer. So oddly enough, many of the animal rights established today in the U.S. were established out of a Protestant Christian worldview that posited that animals, like children, were the property of their parents. But the differentiating feature here is that children grow into adulthood and independence, whereas animals will not. And that difference is significant. So this worldview that is birthed from an observable reality that humans, whether by evolution, God, or both, are clearly the dominant species on the planet due to an incredibly powerful, self-aware, moral, cognizant brain. So these Protestants would say it's from God, others say it's from else. Regardless, this worldview gives us an understanding of how animals are supposed to be properly treated. So what does this difference in belief lead to in action? Well, an animal can be hunted legally, unlike a human. An animal can be mortified humanely by its owner legally. A human, at least after birth, legally cannot. An animal can be raised on a farm, it can be used for slaughter, and subsequently be eaten by humans. Obviously, nowhere in our law can you find that right. So what rights are afforded to animals, you might ask? Well, as a society, we believe that an animal can live and die at our leisure if we take preventative steps to avoid said animal's suffering. For such a reason, most of our laws surrounding animals are wrapped up in the preventing, stopping, or minimizing the suffering of said animals. And it might seem strange to us, but we're not the first generation of people who believe this. In fact, since even the early periods of colonization in North America, we see animal rights laws begin to crop up. In particular, in 1641, we see the first law in the books in Massachusetts' Body of Liberties. And this list of laws established that animals weren't to be treated in cruel or unusual ways. So what would be considered cruel or unusual treatments of animals? To get kind of an idea, let's look at these three cases, two in the U.S. Court of Appeals and one in the Arkansas Supreme Court, to get some examples of what animal cruelty might look like. So the first one will look like occurred in the Arkansas Supreme Court. It's called Ash versus State, and it occurred in 1986. And here's what happened: Daryl and Winifred Hook hosted a pit bull terrier fight night at their house. There were 15 people, including Daryl and Winifred's 12-year-old son. I know, not the smartest cookies. And the police, except for their son, arrested everyone that was there. He was videoing, and the police took his film and a copy of the fight night rules as evidence. Winifred wasn't home when the fighting occurred. So that was a big part of the issue that happened, right? Because she appealed, and here's what happened. Everyone was arrested and found guilty in jury trial. But Winifred wanted to appeal, and here's why. She wasn't home when the fighting occurred. So the issues were that the defendants and their attorneys claimed that the fight night rules were admissible because the state didn't establish that the defendants were aware of its existence, these rules. And two, Winifred argued that she shouldn't be charged but for the promotion of dogfighting since she wasn't present. But the result was that the court ruled that the rules were definitely relevant to the case. In particular because the video evidence, and two, Winifred could in no way have been ignorant of the dogfighting because there were specific structures on her property set up for dogfighting. So dogfighting would be considered cruel and unusual. In another instance, so this was Crawford versus Van Buren County, Arkansas, and it went up to the United States Court of Appeals 8th Circuit in 2012. A woman was charged with hoarding 300 plus dogs They were seized from her property and adopted out. And the animal control officer who filed the complaint could not be found, so the charges were dropped. And then the woman actually argued that her rights were violated for taking her 163 dogs back, or her 300 dogs back. She eventually had to plead guilty to 163 counts of animal cruelty. They weren't fed well. They were covered in fleas. There were all sorts of problems with these dogs. And interesting enough, this actually happened again after the first time. So in 2005, all these dogs were taken away. And in 2006, the police went and seized 201 more dogs from her property. And so after all of this, for years and years, she appealed, but the court ruled that the court didn't err in granting summary judgment in favor of the defendants, i.e., the dogs. The court found that Crawford failed to meet certain criteria and pleading requirements, and so she went to jail. And the last one we'll look at is one of the more famous animal rights decisions. It occurred in the U.S. Court of Appeals, Third Circuit in 2008, the United States versus Stevens. So a person advertised and sold depictions of animal cruelty for money. They're called crushing videos. He would take a video of him smashing an animal to death and sell it to people with some weird fetishes, for lack of a better word. So Robert Stevens advertised and sold depictions of this animal cruelty. It included videos of dog fighting, pit bull fighting, hunting practices where pit bulls were used to catch wild boar. And the trial convicted Stevens on 3 counts of knowingly selling depictions of animal cruelty with the intention of displacing those depictions in interstate commerce for commercial gain. Stevens appealed the decision, and the issue was that whether federal statute 18 USC 48 is unconstitutional because it's violating freedom of speech. Mr. Stevens said that it was a violation of freedom of speech, but interesting here, the holding was that the depictions of animal cruelty are protected under the First Amendment. And so what happened was they tried to, so this person violated animal cruelty, but there were some other things that happened during the ruling that kept it from, that protected his free speech. Interestingly enough, though, the animal cruelty law that just passed through the House and Senate and that was signed into law by President Trump actually prohibits these kind of videos from being sold. So this is why I think animal rights are extremely interesting today, is because it's actually a bipartisan issue, which you rarely see anymore. Both houses of Congress coming together to agree that something should be a law, and that crushing an animal on video isn't in contradiction with First Amendment rights. So thank you all for watching. I hope you learned something.